Thank you very much. Thank you, Mr. Vice Chair, for your wonderful work.
That was quick.
If you want to continue, that'd be fine too. Welcome, Assemblymember Jones Sawyer. And I believe you have bill item number 3, which is AB 396. Anytime you're ready, you may proceed.
Thank you, Mr. Chair, and the rest of the Housing and Community Development Committee. Thank you for considering AB 396 today. I want to thank the committee consultant for her thorough analysis of the bill. Californians with a criminal history are instantly marked with a scarlet letter that blocks them from getting their lives back on track and reuniting with their loved ones. These formerly incarcerated individuals are someone's parent, spouse, child, or friend. One of their biggest barriers to successfully reentering into society is securing a stable housing element. Unfortunately, many rental housing providers only view applicants who have a criminal record as a box on an application rather than as a rehabilitated person. You know that box. It asks applicants whether they have a criminal conviction. Checking that box is usually an automatic toss into the trash can without any opportunity for the housing provider to fully judge the merit of the applicant or the applicant to explain unknown details or inaccuracies about his or her conviction. AB 396 would ban the box on rental housing applications to delay when a housing provider can ask about criminal history. This would allow a very small window for at least some dialogue between the provider and the applicant. Housing providers can still perform a criminal background check and, most importantly, ultimately deny an applicant for their criminal history. However, they should at least judge the qualifications of the applicant to rent an apartment and provide an opportunity for applicants to show proof of rehabilitation. Still, our rental housing market is hot. AB 396 does not require housing providers to hold units during any point in this process. Furthermore, if another qualified applicant comes along, the housing provider is still within his or her rights to choose that other applicant at any time. AB 396 is really about changing culture and perceptions as California shifts towards becoming a redemptive state. It's not about infringing on landlords' decision-making abilities. With all the recent legislation seeking to reduce our prison population, reduce homelessness, and integrate thousands back into our society, I want housing providers to know up front what they're getting into, and for us to all grow comfortable with the formerly incarcerated living among us. I humbly ask for your aye vote. Here to testify in support is Heather Wortkin, a legal policy associate at the Warren Institute on Law and Policy at the University of California, Berkeley School of Law, and Misty Rojo, the campaign and policy director at Justice Now. Thank you.
Thank you very much. For this first witness, please.
Good morning. My name is Heather Warnkin. Again, I am an attorney and legal policy associate at the Warren Institute on Law and Social Policy at UC Berkeley School of Law, and I'm here this morning on behalf of the Women's Foundation of California Women's Policy Institute. So following a prolonged period of mass incarceration, as the state of California currently implements major policy measures such as realignment and Proposition 47 to support the unprecedented return of thousands of citizens to their communities, so must it take appropriate evidence-based measures to set families impacted by the criminal justice system up for success. AB 396 addresses head-on one of the most urgent and timely of such necessary measures, access to a safe and stable place to live. Approximately 70 million people in the United States, and specific to California, 1 in 4 adults, have an arrest or conviction history that can show up on a background check for housing. Although landlords are not legally required to, a vast majority of housing options, including over 80% of private housing providers, conduct background checks, leaving applications rejected, often based solely on the existence of a criminal record before the consideration of any other factor. Housing providers often justify background checks as promoting the safety of tenants and avoiding liability. These concerns are reasonable. However, they are largely unwarranted, and I'm going to tell you why. A study released this year concluded the existence of a criminal record is not predictive of a successful tenancy, finding no empirical connection between landlord liability nor the ability of the applicant to meet the obligations of tenancy. This affirms what an array of research for years has already indicated, that recidivism declines over time, and a criminal record, including violent offenses, is not predictive of future criminal activity after 5 years. A diversity of stakeholders across public and private sectors agree what a range of research demonstrates, that finding stable housing as soon as possible, particularly within the first month of release, is critical to successful reentry, decreasing the probability that that person will return to prison in the first year. So California's 61% recidivism rates, one of the highest in the country, should not surprise us. People leaving incarceration face numerous challenges after release, spanning from securing employment, obtaining medical care, overcoming substance abuse. Now, based on barriers such as these, the moment of release from incarceration places individuals at an extremely high risk of residential instability. Furthermore, individuals with records are often barred from living with or rejoining their family members. Though a lack of housing cannot be used as a reason to remove a child from their parents' care, it can be used as the sole reason to prevent reunification, which is often the most devastating and reverberating impact of blanket discrimination on millions of families. Now, many housing authorities will evict or deny housing to an entire household, including children, if one of those household members has an arrest, conviction, or pending criminal charge. So given that in California, 2/3 of incarcerated women are mothers of children under the age of 18, this impacts women disproportionately. The number of women in prison grew 646% from 1980 to 2010, which is 15 times the rate of men. Because people of color are disproportionately represented in the American criminal justice system, automatic bars also unnecessarily result in a disparate racial impact, threatening the rights of applicants to be free from unwarranted housing discrimination. Though facially neutral, this makes such policies highly suspect under the Fair Housing Act. And finally, this bill would be a tremendous step in the right direction in addressing widespread homelessness. The Federal Interagency Reentry Council, which represents 20 federal agencies working to make communities safer by reducing recidivism, found a strong link between incarceration and homelessness. A link that the state of California, ranking first in the nation in poverty and third in the nation in homelessness, simply cannot afford to ignore. In cities such as LA and San Francisco, 30 to 50% of people on parole are homeless. Access to safe and stable home is not only a basic human right. It is a necessary component of the ability of millions of Californians and their children touched by the justice system to thrive. Now, given the plethora of evidence-based reasons to provide applicants the opportunity to be evaluated on their qualifications, not simply their past mistakes, we respectfully ask for your support.
Thank you very much. Next witness, please.
Good morning. Thank you. Again, my name is Misty Rojo, Campaign and Policy Director of Justice Now. I can skip over statistics. She named even the ones I had in regards to women, particularly mothers, and jump right into oftentimes when mothers are coming out, reunification that is allowed is a very short timeline, so allowing people to have access to housing without questions of their criminal background is extremely important. I myself re-entered about 6 years ago, and I came out with 4 boys who were teenage aged, so the likelihood of me finding transitional housing that would accept the liability of 4 teenage boys was non-existent. Reunification for my boys with me was non-existent because I could not find housing. I spent the first 3 years of my reentry process homeless. I did stay for a short time with someone who was on Section 8 housing and had to lie to my parole officer so as to not jeopardize their housing, just for them to put a roof over my head. Had I had parole officers who were not understanding and seeing that I was genuinely trying to get my life back together and re-enter and work and do the things that I needed to do, I could have been violated and put back into prison simply for being homeless and not having an address to give or lying about said address so as not to jeopardize the housing of the person who was providing it to me receiving Section 8. Additionally, currently, even now after 6 years, I have available to me only about a third of housing listings that I can afford, because only about a third of them do not mention asking about criminal convictions. Additionally, I have a son who will be being released from county jail who has fallen into drug problems, as we see the reverberations of incarceration and what it does to families. My ability to offer him housing and be a mother and be a support system for him is jeopardized through these, because then we become a double jeopardy of two felons trying to live together. I would also like to add that statistically, the things that support the statistics on recidivism and reducing barriers and reducing recidivism is, I know personally, the instability and stigmatization drives the road to recidivism. When you feel like nobody wants you and you're not worthy, then sometimes the best place for you to be is back behind bars. But that should not be the way that it is. We should be able to re-enter successfully. I am a quote-unquote violent criminal. I have not offended in 6 years. I am stable. I am working. And reducing the barriers allows more people to end up like me on a road to success and not back into behind bars. Thank you.
Thank you very much. Additional witnesses in support of the bill, please step forward.
Good morning. Melinda Blake with Californians for Safety and Justice and Support. Thank you.
Thank you much. Next.
Arona Lofton, Reentry Housing Case Manager. Strongly support.
Thank you. Next.
Andrew Grinberg, representing myself, resident of Oakland, in support.
Thank you.
Stephanie Medley, Rise Youth Center in Richmond, in strong support.
Thank you.
Scott Huggins, on behalf of the City of Oakland, strongly support.
Thank you.
Emily Harris, co-sponsoring organization, the Ella Baker Center, in strong support.
Thank you.
Marlene Hurd, Healthy Communities, City of Oakland, in support.
Thank you.
Zella Knight, representing Zella Knight, in strong support.
Thank you.
Morning, Mr. Chair and members. Kevin Baker, American Civil Liberties Union of California, also in support.
Thank you much.
John Bowders, Policy Director, Housing California. The board does not have a position on the amended language, but we wanted to thank the author for his efforts on this, and to all our partners in the restorative justice community. This is an issue that we'd like to see addressed. Thank you.
Thank you much. Witnesses in opposition of the bill, please step forward. Welcome. Let's start with the opposition witnesses.
Good morning, Mr. Chairman.
Good morning.
And members, my name is Deborah Carlton. I'm with the California Apartment Association. We absolutely understand what the member has to say and what his witnesses have to say. Of course, the private housing market struggles each day. We work with local law enforcement to ensure that our housing is safe. Our challenge, of course, on the opposite side of the same coin, is that owners who operate in low and moderate income neighborhoods struggle to provide safe housing. A lot of it's demanded by the tenants that live there as well. If you take away or hinder our owners' ability to ask about criminal background, or if you hinder or limit the time period, such as this bill, the 14-day period, and I believe we're going to talk about what that actually means, you obviously make it a big challenge for those rental property owners to provide a safe and peaceful place for owners to live. You're right, realignment has created a challenge for many of the owners in some of our neighborhoods, and they work with what we call a crime-free housing program with our local law enforcement, and local law enforcement as part of that program demands that we do criminal background checks and ask the questions. So we're going to have to look for ways to balance those who need to find a place to live with those that I think make a big challenge for our owners to provide a safe housing. So for that reason, we oppose the bill today.
Thank you. Thank you. Next witness, please.
Members, Mr. Chairman, Ron Kingston, representing 5 regional apartment associations, Apartment Association in California Southern Cities, Orange County Apartment Association, North Valley Association, East Bay, and NorCal Association. There are 5 issues that I would like to bring to you as to the reason what constitutes the reason for our opposition. First, we do not dispute that the witnesses' claims about difficulty of finding housing, but that puts the entire burden on us. That burden is underscored by decisional law issues. There's substantial case law making us absolutely liable for the conduct of citizens, our tenants, and as a consequence, we have to take precautionary measures. And these precautionary measures do ask in the rental application. Rental applications are not bifurcated as has been suggested by the proponents. When a tenant applies, a prospective tenant applies, it is a one application only. In other words, we ask all the information about a tenant. We ask about their credit history. We ask about their previous housing. This bill effectively and essentially precludes us from asking about the history of where that applicant has been residing or previously residing. We can't ask that because of the possibility of stepping into violating what the author is requesting us. We can't ask for not only where they are currently or previously living, because they would have a gap, and that gap could be where then they were incarcerated. We can't ask about credit, because all of a sudden, if that happens, that credit report may reveal kind of a gap, and that gap could be when they were previously incarcerated. We can't ask for credit-related transactions because those transactions could be related to the crime. And also, this requires us to freeze the housing availability. This is a pretty substantial issue for us. And what I mean by that is we have to put the housing that's currently available on hold for 14 days. This is a pretty material thing. That costs us money in a sense that we lose money being able to rent the housing immediately, because we have to, according to the new version of the bill, we have to wait to allow the dispute of the applicant in that case when we have a whole array of possible qualified applicants. This is really, really problematic for us. HUD has been discussed by one of the witnesses. HUD has a zero-tolerance policy of renting to previously convicted felons. Zero. And we say that in our letter. We explain that in our letter as to why. Yet if HUD has a zero-tolerance policy, why should the private industry be burdened with that and provide essentially housing? This is particularly problematic where we have government saying you have to, and this bill says you have to deny, and this bill says we have to accept as private citizens, accepting all the liability. It has been discussed about recidivism. Recidivism is extremely high. Statistics don't lie. We, in our research, we relied on various, the California static risk assessment, and those risk assessment data, which is statewide reported, it has been done annually for years, shows the recidivism is tremendous. And a lot of those acts, those felony acts, are related to sex offenders. We have to consider sex offenders now. We have to wait and put on hold all our properties for arsonists, for those that had previously committed homicides. We have to wait for that dispute. Who pays for, who reimburses us for these types of costs? This bill doesn't answer that. So what you're asking us to do is put our properties on hold, allow for the dispute, and totally reorganize our qualification standards, our qualification time periods, our qualification questions. We're going to go to the Fair Credit Reporting Bureaus and have them totally revamp their processes. And this bill, we believe, is wrong-headed for those and many other reasons. You have our lengthy letter of opposition. Thank you.
Thank you. Next witness, please.
Mr. Chair, members, Steve Carlson for the Apartment Association of Greater Los Angeles and the Santa Barbara Rental Property Association. I won't repeat what my colleagues have indicated. A couple of additional observations. Most of our members are small property owners. They're not large, sophisticated property owners, yet the bill imputes a level of sophistication in terms of looking at mitigating factors, what might be acceptable, what might not be acceptable. And we don't think that our members have really the ability or the qualifications or the expertise to be able to do that. I think it's unfair to impose that duty on them. We are afraid of liability. So on the one hand, we have a whole set of criteria that if the applicant is ultimately denied, we are certain that there are groups and perhaps some of the sponsors at the table that are going to sue the owner for not acting reasonably in denying the application. On the other hand, if God knows, we hope it doesn't happen, but if that person were to reoffend on the property, then the person next door who might have been the victim will say, well, you acted unreasonably in renting to him. It's a catch-22, an impossible situation, and we absolutely are with you, Assemblymember Jones Sawyer, in how important the issue of housing to deal with recidivism is. We unfortunately don't believe that burden should be placed as much as it is being placed on this on small property owners. One other item that I would raise to the group is that in many of these communities, our owners operate under rent control, particularly in Los Angeles. That provides an additional burden and complication as you're renting to somebody, and if you make that mistake, the ability to get a new tenant in, to evict that tenant is also very difficult. We absolutely understand what's going on. We think that the approach that the Speaker has in 1056 is a better way to go, but to impose this kind of burden on a private market, particularly when so many of these folks are broadly ethnically diverse owners, but are small owners, this becomes, we think, an unworkable, if not impossible, situation for them.
Thank you very much. Any additional individuals like to oppose the bill, please step forward.
Catherine Pettibone, Civil Justice Association of California, in opposition.
Thank you. Next, please.
Mr. Chair and members, Pat Moran with Aaron Reed and Associates representing the San Diego County Apartment Association, who are opposed to the bill for the reasons previously stated by the witnesses. Thank you.
Thank you.
Catherine Borg with the Western Manufactured Housing Communities in opposition.
Thank you.
Dan Firestone representing Contemporary Information Corporation. We strongly oppose this bill for reasons described. Thank you.
Thank you.
Mr. Chairman and members, David Milton, California Association of Realtors, and we are in opposition to the measure as it is before you.
Thank you. Anyone else? Before we come to the, let's find out whether or not the author is accepting the amendments as suggested. First of all.
Yes, we're accepting the amendments.
Very good. Then we, in fact, have come a long way. When the bill was initially introduced, in fact, the earliest version actually had was going to create a protective class out of FIHA. And I think both parties have worked tremendously on narrowing the scope of this bill. So I want to thank the author's office and the author himself for working with us as well. So with that, I want to bring up both the proponents and opponents and back to the desk for questions and answers. And I think the opposition has raised some concerns, and I'd like for the author or any of the witnesses, proponents, to respond either currently, right now, or as part of your close. So, but before I do that, let me open it up for Q&A, Mr. Steino. So, I do have a couple questions, but could I ask you to respond to some of the issues raised before I make my comments?
Well, let me at least begin, and then I'll have our sponsors kind of chime in. Let me just begin as someone who's the former director of real estate for the city of Los Angeles, who had tenants and had to deal with protecting taxpayers' money and liability. As someone as unbelievably respectful of the housing market, the apartment owners, and the challenge that they have, especially in the inner city, in providing housing. And I guess most important, as someone whose basically common law wife is an apartment owner, who, if I provided something or legislation that was unreasonably onerous, that would probably be more painful to me than anything else. I would like to say that we're willing to work with the community that provides this housing. Our intent was never to impose any undue hardship on them. In fact, if the 14-day waiting period is too much, we can shorten it so that they do not have an undue burden on them being able to rent their facilities, their apartments in a reasonable period of time. That is not the point of the legislation. And the sponsors will read to you about even what HUD has asked of in 2011, what HUD has asked about the formerly incarcerated and what we need to do. And so I just wanted to begin by saying the intent was never, and I repeat it one more time, never to allow any apartment owner to do a criminal background investigation. In fact, we believe the time that it takes to do that is not as long, and the time to do it, even during the background check, to do it almost immediately after, if you're sure you want to rent to that person. You can almost do it in a succession where they don't lose time, and I think we can walk through that. But first, I need for individuals to be amenable to at least to even try to work with talking to people who are formerly incarcerated. Because at the end of the day, we have not, I repeat, this legislation does not strip their ability to say no. And if I have to put in language, or if they need language to protect them from any liability afterwards, that would give them some kind of assurances that they won't get sued if something happens, but this is a litigious state, people sue anyway. But if there's anything to give them some type of comfort that the intent of this bill is not to set them up to be sued, we're more than willing to provide that language in the bill. And so.
Yeah, I would just like to respond with the evidence related to three critical points that were raised by the opposition. As the Assembly member stated, this bill is not in any way intended to infringe upon property owners from not considering the information of a criminal history. As the Assembly member stated, this is about banning the box that puts those applications in the trash can before anything else gets considered. First, I would like to address HUD. So the opposition's testimony noted a zero tolerance position and a position out of HUD that discourages the use of this information. That is actually very afar from where HUD is currently on this issue. In June of 2011, the HUD secretary issued a letter to public housing authorities across the entire nation proactively encouraging more flexible admissions policies for persons with criminal histories, encouraging every single HUD-assisted owner to, quote, develop policies to allow formerly incarcerated individuals to join their families, and, quote, noting that people who have paid their debt to society deserve the opportunity to become caring parents, supportive parents, and caregivers to their elderly parents. Secondly, I would like to address what is clearly a main concern of the opposition regarding their liability. As I stated already, we have for years had an array of research affirming that recidivism declines over time and that a criminal record, including violent offenses, is not predictive of future criminal activity after 5 years. But what is a newer body of research emerging critical to this concern is the evidence to now support that there is not a nexus between using this information and landlord liability or the ability of a tenant to have successful tenancy. So I mentioned that brand new study that just came out this year. I'm going to give you a little bit more detail on what that actually stated. So this study examined the concept of foreseeability as it pertains to potential landlord liability from renting to an applicant with a criminal record whose actions they are concerned to harm another tenant, and also addressing the relationship between a criminal record and the ability to meet obligations of tenancy tenancy. It concluded there is zero empirical evidence establishing a relationship between solely having a record and an unsuccessful tenancy. And based on this empirical demonstration, urged that criminal record is not a reliable indicator for future tenant behavior and therefore should not serve as a proxy for tenant dangerousness or liability. And lastly, I will note, and this is in the analysis of the bill, this bill, and again, the banning the box on these housing applications to open up in this critical moment in time in public safety reform, where we're understanding the impact of this on millions of families, this would really make California a leader in a measure that's been taken in a couple of other local jurisdictions, including the city of San Francisco with the Fair Chance Ordinance, and the state of Oregon, which in January of 2014 passed a law prohibiting subsidized housing providers from discriminating against prospective tenants based on arrest records or certain type of criminal convictions. I'm happy to take further questions as well.
Thank you very much. And first of all, I'm very pleased to hear that you're open to making modification to the 14-day, because I think that was a concern of mine also. And I do want to encourage both parties to continue talking about this, as well as other possible amendments, because one of the other things that I thought about has to do with expungement of records, for example. I think specifically the language appears in section C3 of the proposed measure on page 7, and it talks about a conviction that has been judicially dismissed, expunged, voided, invalidated, or otherwise rendered inoperative. I had some issues with the term expungement, because there are some situations where a person has in fact served the time before asking for the expungement. So some of those crimes could be, let's say, rape or robbery or otherwise. So the fact that the crime has simply been expunged doesn't mean that the person was not convicted. So I wanted to look into that a little bit more, as well as other felonies, for example. So that may be concerns to the landowner. Because we do, as I stated before, we have come a long way. I think when we first started out, we were going to create a protective class. So you have made a lot of concession as well. So I want to find that balance between, the two parties. And so this may also, be of concern, is of concern to me. So if I could ask you to continue the dialogue with the landowners and the apartment owners on these two fronts, at least on these two fronts, I would be very happy to support the bill. So would you commit to doing that?
Yes, Mr. Chair, because I just want you to know, and maybe we just, we get wrapped up sometimes into naming things, and maybe banning the box was not the correct title, because we're not really banning the box. We're holding off when you check the box, temporarily suspending that time until the end of the application. That's really what we're asking for. And as far as someone's criminal record, the main goal of this is to get our society used to having formerly incarcerated come back in society. So to your point, even expungements, I would rather have someone who's been a credit to society, who's worked a hard life, raised their family, now wants to rent, and then have a dialogue with a landlord, express what they've done for the last 20 years, but maybe 20 years ago they did something really horrendous. But now they've changed their life around. And because it was expunged, I would rather have them have that dialogue, because I'd rather have them learn that people can turn their lives around. And I'd rather have someone tell them, yes, I was a former rapist, but I turned my life around. And now I'm a credit to society. I'm a deacon in the church. I go to work every day. I'm a soccer league coach, all of that. I'd rather have that happen than to hide it from potential landlords. So, yes, I am definitely willing to work with you on that front.
Thank you very much. Let's see. Oh, Mr. Chu, go ahead.
Thank you, Mr. Chair. I first want to take a moment and thank the author for moving forward this policy proposal, which I do know I think has been misunderstood by many. And I appreciate the clarifications. As you've said, we're not saying that criminal backgrounds cannot be considered. We're just saying that we don't think that initial biases at the beginning of an application should rule the day. Certainly in my city in San Francisco, we grappled with these issues. We worked with the apartment association and the realtors. We were able to resolve them and implement a policy that has worked. And certainly in our city, like in many dense urban cities around the state, we have a significant population of ex-offenders, but we have not had issues. And all that being said, as a state, we have made a decision that we want to give folks a second chance, that we believe in rehabilitation, and of course it's important to house folks in order for that to actually be an actuality, particularly in the wake of Prop 47. So I am planning to support this. I appreciate the amendments, and I'm happy to move this at the appropriate time.
Thank you very much. And Mr. Steinoff.
Yes, for a point of clarification, may I ask Mr. Ron Kingston to please come up and, if you wouldn't mind, addressing the HUD issue raised by Mrs. Workin?
Thank you, Mr. Steinworth. The issue is this, and let me quote, if I may, quote to you the HUD policy and regs. This is out of 24 CFR 5.854A. It says in pertinent part that landlords are prohibited from admitting an applicant if the applicant or member of the applicant's household has been evicted and from federally assisted housing or drug-related criminal activity. The point is that HUD does have a zero tolerance. We have the citation. The citation is not lying. We quote it. And the point is, it is an absolute policy. This is not an advisory. This is the regulation of the federal government. We have absolute liability. We cite, by the way, Mr. Steinworth, we cite the specific decisional law giving us and, in a sense, burdening us with this type of liability. So I don't know how we ultimately come down on this, but it is a very specific concern. Unless we are relieved of our liability under the UFAN case and under the Ann case, then we have something to talk about with the author and sponsors. But the case law is absolute. And the third and final thing, if I may just vector, I don't think the author has in mind to totally revamp our entire review and approval process, but this bill does exactly that.
I respectfully affirm that that is actually inaccurate. Federally subsidized housing providers only are required to consider an applicant's criminal history in a narrow set of circumstances, such as when the applicant is a sex offender with a lifetime registration requirement, which also happens to be a crime type, not like others that are not eligible for expungement. So again, we're talking about a very narrow set of circumstances that we'd be happy to explore in further depth the implications of with all parties around the table, and again would just affirm a very bold and very nationally significant step that HUD took in 2011 when they urged all providers nationwide to allow for more flexible policies to allow formerly incarcerated individuals to join their families.
And forgive me, Workin, would you please tell me what you're citing specifically?
Sure. I am citing the June 17th, 2011 letter from the HUD secretary to all HUD-supported properties, and we'd be happy to provide a copy of this after the hearing.
Thank you very much. With that, would you like to close?
I just want to assure the committee that if we're let out of this committee, we will work together, and if I have to serve as referee, I will do that to ensure that we can move this forward. Because for me, and I think also for the apartment owners, I don't think they just want to, at hand, just say no renting to anyone, because I think they also feel that that they need to bring people back into society. I just need to work with David Chu, our Assembly member, who evidently has had some success at getting that through, get some of his recommendations, speak to the thing that Assembly member Steinworth is talking about, and just work with both parties to make this happen. For me, just having the ability to have people start to talk to the formerly incarcerated and vote them up or down like we do in the Assembly, and not have the feeling that they will be prosecuted or they'll feel any repercussions from it, is the most important thing that we need to do.
Thank you very much. Madam Secretary, please call the roll. The bill has been moved. I need a second, please. I can second.
Motion states, do pass as amended and be referred to the Committee on Appropriations. Chow?
Aye.
Chow, aye. Steinорth? No. Steinorth, no. Burke? Chu?
Aye.
Chu, aye. Gaines? Gaines, no. Lopez? Mullen?
Your bill is on call. You need 2 more votes.